Have with us Mr. John Oloyede. He's also a legal practitioner. Good morning.
Good morning.
And the Bayelsa PDP crisis is still very much on, and somehow lawyers are already divided on this, and everyone saying anything on this matter, interestingly, still quotes the Constitution and the same Electoral Act. Yeah. What do you make of this?
Well, I'll start off by saying I heard Mr. Agbaje talking about the fact that the particular provision of the Electoral Act, Section 8710, cannot avail PDP in this matter, because any provision of law that goes contrary to the provisions of the Constitution is null and void to the extent of its inconsistency. Now, my view on that is this. The Electoral Act itself has constitutional flavor. It has the status. It's an act that is given due recognition by the Constitution. So the provisions thereat, as amended, are very powerful. And the way we should look at it is that there was a mischief at a point in time that the lawmakers intended to eradicate, which was this. Whenever somebody is aggrieved about primary elections, they rush to court to try and get an order of injunction, frustrating the whole primary elections. At times, the whole party is frustrated out of the general elections because they cannot present a candidate. Because somebody has rushed to court, the court makes an interim order. It lasts beyond the time envisaged by the Electoral Act. And so the lawmakers felt this is a mischief. You will remember what happened in Rotimi Amechi's case. That was a precedent that will be for that purpose alone. It may never be followed again. Somebody contested an election on the platform of PDP, won the election, and ultimately the Supreme Court held that this person that contested the election ought not to have been presented. And the person that was never presented to the public are meant to vote. Generality of the people, they are meant to vote. But somebody that was never presented to the public was sanctioned by the Supreme Court to become governor, and that's why Governor Rotimi Amechi is there today.
Is it similar to this case?
I'm trying to clear the air about the validity of the section of the Electoral Act, Section 8710, that PDP is relying on, and which some colleagues are trying to knock off as, it's something that is contrary to the intention of the Constitution, the letters of the Constitution. Now, I do not subscribe to the view that, when access to the court is curtailed by any law, that provision is unconstitutional. No, because there are situations, for instance, there's something we call pre-action notice. You want to sue a government agency, a public officer. If you do not give a pre-action notice to that agency, to that public officer, you cannot go to the court. And the Supreme Court has held that the fact that there's a procedure, there are certain steps you have to take before you approach the court, does not mean that provision requiring that you must give pre-action notice is unconstitutional. So it is not a general thing that, once a particular law says the court cannot pronounce on this, it means that it's unconstitutional. That is not correct.
Let me, staying with the Electoral Act, that Section 10, said, notwithstanding the provisions of the Act or rules of a political party, an aspirant who complains that any of the provisions of this Act and the guidelines of a political party has not been complied with in the selection or nomination of a candidate of a political party for elections may apply to the Federal High Court or the High Court of a state for redress.
Yeah.
Nothing in this section shall empower, that's subsection 11, shall empower the courts to stop the holding of primaries or general elections under this act pending the determination of the suit. Yeah. Now, my question has to do with, is it contradictory? INEC did not show for this primaries, but now it's saying until the determination of that suit. In other words, by my understanding here, that the primaries are supposed to go on while the suit is being determined. So did INEC fail in meeting with the Electoral Act? Did INEC contravene the Electoral Act by not showing up there?
Well, by not showing up, this act is very clear. There's no contradiction in that provision. It says, look, you have a right to go to court to seek redress where you feel that certain provisions of your party's constitution or the Electoral Act have not been complied with. But that's the second part, that's the proviso, provided that this particular provision of the first one is not an umbrella provision for you to get an order of injunction stopping the holding of primary elections. There is no contradiction. The law just clarifies that you can go to court for redress, but no matter what happens, the court does not have to give an order of injunction to prevent the holding of that elections. And you see, the problem we have in this country is that oftentimes we comment on issues without actually looking at what is generating the controversy, which is the order of Oloyede. I have had the privilege of reading through. Now, what the court said, to the best of my understanding, is that look, you have reliefs, you are asking for interim orders 1, 2, 3. These are wide enough to, and you've given me good reasons why I should make an order. I should make an order stopping the holding of primaries totally. You see, you have to understand what was before the court. What they took before the court was, look, we want the court to say that there is no need for primaries because Governor Silva had won a previous primary election in January 2011 and there's no need to hold another one. But alternatively, if the court is of the opinion that, oh no, that one does not hold water anymore, we have to hold another one, then PDP cannot prevent me from participating in that primaries. That was what was before the court. In the interim, tell them not to hold the primary elections. And then the judge has done no wrong, because just like in the Boris case, it was widely reported that the court gave an order and later the judge came and said, I didn't do that. Now, what Justice Oloyede said, what I read, was that, look, I have read your affidavit in support. The court will be in order to grant interim reliefs 1, 2, 3. But, you see, the Electoral Act as amended does not preclude me from knocking off whatever steps are taken after today if I find that, if I hold that, look, that primary election should not have held. So what I'm going to do is I'm going to give them 72 hours to show cause why I should not order that there should be no primary elections at all. They should come and tell me why I should not order that.
But again, knowing for that 72 hours the primaries would have been held.
Yes.
So couldn't he have said, just trying to get into the minds, say maybe in 24 or 48 hours before, or put a hold on that primary so that they can come show to him all those reasons before the primary?
I'm going to answer that question, but you see, it's arguable. Because what I am even saying is that the order was not positive. There was no positive order. Yes, I heard Mr. Agbaje saying, ordinarily by the case of Ojukwu and Governor of Lagos State and Ojukwu, that was the authority he wanted to talk about. Once you are served with process, you are supposed to hold on, even without a mandatory order of court. But in this particular instance, the issue is not that, oh, they had been served with process. The issue is an order has been made. So we should distinguish that fact. But I am saying that what the court said, the reasoning before the final order, is that, oh, I could have granted, but the era where once a party does anything under its constitution, it's a god unto itself, is over by the amendment to the Electoral Act. And so even if they go ahead and do anything, don't worry. You are not going to suffer irreparable loss, as in the case of Kotoye and CBN. That's what the court said. That so what you are saying is that the rest will not be saved if the court does not make an order now. You don't read a part of a ruling in isolation. If only people will read everything the judge said, they would appreciate where it was coming from. That, oh, you are in order. But what you are asking for, I don't want to do that now. What I want to do is, I'm going to tell them to come and show cause why I should not order that there should be no primary election at all, because you had been chosen prior to now in January. That was the order.
If that's the understanding,
yes.
Now, why is INEC not accepting?
Okay, now going to your question, INEC, that why would INEC breach the law? Now we have to appreciate the fact that INEC enjoys an observer status in respect of such primary elections, and the law says they may. That is permissive. It's not mandatory. Now that is the interpretation given to that word. There are no hard and fast rules, but oftentimes when that word is used, may, it means you can decide to go, You may decide not to go. It does not affect the validity in the final analysis of the outcome of the primary elections. So, if INEC felt that, look, because we have an observer status, we do not want to be seen as taking sides with anybody here, we will just stay away. I don't think there's anything wrong with that.